Welcome back. You're listening to This Week. On Friday, the Supreme Court ruled that Ireland's proposed ratification of a major trade deal between the EU and Canada was unconstitutional. The Comprehensive Economic Trade Agreement, or CETA, has been a thorny issue for the government for some time. Part of the deal includes a mechanism for resolving disputes using a panel of experts instead of the Irish courts, and the Supreme Court found that this part of the deal would create a parallel jurisdiction and breach judicial sovereignty in the state. However, 6 judges of the court agreed that the government could fix the problem by introducing legislation which would give the courts a role in the dispute resolution process. The case was taken by Green Party TD Patrick Costello, who feared that the deal could negatively impact on the government's ability to introduce tougher environmental laws which might be in conflict with the trade deal. The ruling has opened up fresh divisions in the Green Party over how to proceed with the deal. Well, we're joined now by Neasa, another Green Party TD who has supported her colleague in taking this case, but who is currently suspended from the parliamentary party after voting with Sinn Féin on an unrelated motion. Neasa, good afternoon. Welcome to the programme.
Good afternoon.
The government says it's committed to ratifying this trade agreement. The constitutional problems with it can be fixed with legislation. We know that now from the Supreme Court. And the Taoiseach says there'll be no need for a referendum. Is he right?
Well, certainly the Supreme Court has set out, and it was a judgment of 7 with 1 dissenting from this pathway, but they set out a pathway whereby they could legislate to remove the requirement for the referendum. But currently, it would be unconstitutional to vote this arbitration through. So the actual trade part of CETA is in place and has been in place for a number of years. We are already trading under CETA. But it's this arbitration part that is not in place. And it is not in place not just because of Ireland, but because of many countries in the EU have not voted it through. So I think that the response of the Taoiseach was not a surprise to me, that they intend to go forward. I don't think it's quite as straightforward as they believe it to be. It's not clear from the judgment even whether CETA itself would accept those changes to the arbitration law. So it's not clear that the actual agreement in question would. But also fundamentally, if we change our 2010 arbitration legislation, it opens up an ability for us to engage in ISDS, these arbitration suits or arbitration investor courts.
Yes.
In a way that we haven't been able to before. Our constitution really protects us. We're quite unique in the EU. And I think it might be wise of the government to take a moment to consider whether they want to sidestep our constitution in this way.
They're not sidestepping the constitution, though, if they do that. The Supreme Court has said this is the cure for the problem.
Well, the Supreme Court has upheld the idea that currently it is not constitutional to enter into an agreement like this that would effectively remove power from our judiciary. So I think that is a very serious matter. And I have to say, I support my colleague, Deputy Costello, in saying this is so serious. You know, we have Mercosur coming down the tracks. We have a number of trade deals. Most countries in Europe that would be similar to ourselves are actually removing themselves from agreements like this. So we can see, for example, Germany this week removed itself from the Energy Charter Treaty, a huge step by them because of concerns around areas like this. So I think it's time for the government to have a really serious consideration. Why would we be moving against the tide as other countries are kind of considering their position when it comes to arbitration?
Are you saying then that a referendum, divisive and all as those can be, would be preferable to legislating to fix this problem?
I think it would be a very, very serious move to enable arbitration and ISDS systems as a basic principle of trade agreements for Ireland. And I think we have some other referendums coming down the track, not least the referendum on the woman's place in the home, and that this could be added to that slate of referendums. It would be possible. And I think it is of such importance that it would be worthwhile doing that. We're seeing Holland being sued for reducing its coal sector, Italy being sued for billions for its reduction of oil. This is serious stuff.
If legislation is introduced, if that is the preferred route that the government wishes to take, will you be voting against it?
I wouldn't be able to support any legislation that is specifically to enable ISDS courts.
There's 2 years left in this government. Do you expect this issue to be dealt with in that time frame?
You know, that's an interesting thing because, as I said, many countries in the EU have actually not accepted the arbitration clauses of CETA. And so we are within a list of other countries who have failed to do so. And we can see that the Energy Charter Treaty is starting to break down because of clauses like this. So I think that CETA in general, there's no kind of timeline on this. There's no pressure on our government. There's no timeline that has been made obvious to us. And therefore, you'd wonder, does it need to happen in the next 2 years? Should there be a moment where we really consider our position in terms of ISDS and those kind of international agreements when it comes to arbitration?